Senator from Vermont.
Madam President, I ask consent the call.
Order in the chamber. Without objection.
I ask consent the call of quorum be dispensed with.
Without objection.
And I'd ask for order. We still don't have order in the chamber.
Order in the Senate, please. Senators, please take your conversations outside. For the information of the Senate, with respect to the nominations just confirmed, the motion to reconsider is considered made and laid upon the table, and the President will be immediately notified of the Senate's action. And the Senate will resume its legislative session. Has resumed.
Madam President.
Senator from Vermont.
Madam President, we've confirmed 3 judges from Georgia. I compliment the 2 senators from Georgia for their hard work, both with the Judiciary Committee and with the White House. In that, I am sorry they had to wait so long. On this side of the aisle, we cleared every one of those for a voice vote months ago. I'm sorry that your side wanted to delay it, but I was glad to see the 100-0 vote and the voice votes afterward. And I compliment the 2 senators from Georgia for sticking with their nominees. Madam President, I'd like to yield to the distinguished senator from Utah, Senator Lee, for 4 minutes.
Madam President.
Senator from Utah.
Madam President, in 2013, the country learned that the government, specifically the NSA, had been collecting and storing enormous amounts of information about American citizens, and that the data collection at issue was not limited to those who were actually suspected of terrorist activity, or even necessarily to those who were connected to those suspected of engaging in terrorist activity. Many were understandably very concerned about how much and what kind of data was being collected and whether or not this information could be or had been abused by government officials. Today, proponents of the metadata program claim that it cannot be used to identify ordinary American citizens. But earlier this year, researchers at Stanford University proved that the very type of metadata collected under Section 215 of the Patriot Act could be used to uncover a lot of information, including information about a person's politics, about what kind of medication they might be taking, about where they go to church, and so on and so forth. This USA Freedom Act is a bipartisan piece of legislation that would end bulk data collection of the metadata currently gathered by NSA. And it would help address the problem of the American government spying on its own citizens without cause. It also would improve transparency for the data that NSA does collect. It has the support of leaders in our intelligence community, the Department of Justice, civil liberties groups, the National Rifle Association, and a whole bunch of tech companies. Opponents say it will impair our national security. They say this bill will keep our intelligence community from protecting us. But what opponents of this bill fail fully to appreciate is that most Americans are deeply, deeply concerned about the collection of their own personal information. And this bill is an opportunity to strike a reasonable, common-sense balance between protecting Americans' privacy and, at the same time, protecting our national security. Well, I believe that there are honest, decent people working in our intelligence community, and well, I think this is the norm, the overwhelming norm. I think it's always important for us to heed a warning given to us centuries ago by James Madison. In Federalist 51, James Madison wrote, "If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, The great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. Congress should address this issue now. The provision of the Patriot Act authorizing this kind of data collection expires just after Memorial Day this coming year, and it's important to adopt a compromise well ahead of this deadline that all interested parties can accept. Thank you, Madam President. Mr. President.
Mr. President, I thank the distinguished senator from Utah who's worked so hard on this. You know, it's been more than a year since Americans first learned the government had been secretly sweeping up the telephone records of innocent Americans, whether there's any connection to terrorism or criminal activity. I introduced the original USA Freedom Act last October with Republican Congressman Jim Sensenbrenner. The Judiciary Committee held 6 hearings, public hearings, to address these issues. We learned that the bulk phone records had previously advertised thwarted 54 terrorist plots, or even dozens, or even a few. In fact, we learned through our public hearings, after all the talk about we needed this because it thwarted 54 terrorist acts, it may have possibly helped on one. Now, that is an important fact for those who now argue the NSA's bulk phone records program is somehow essential to our fight against ISIL. It did nothing to stop ISIL from starting in the first place. But our bill protects Americans, enhances privacy protections. It ends indiscriminate data collection, but it keeps the tools our intelligence community needs to protect our nation. That's important to remember, and that's why our intelligence community strongly supports this bill. I worked in law enforcement. I'm a native of Vermont, where the right of privacy is cherished. I know we can have both liberty and security. The USA Freedom Act provides for common sense reforms to government surveillance. It promotes greater accountability and transparency of the government's surveillance programs and improves the FISA courts. It's a carefully crafted bill. It builds on what the House of Representatives did. It has the support of the Director of National Intelligence, the Attorney General, the Director of NSA, American technology companies, the privacy and civil liberty groups across the political spectrum, ranging from the NRA, the ACLU, and Tech Freedom. Lawmakers from all parts of the political spectrum, from the right to the left, support this bill. They know it's a reasonable and responsible compromise. And that's fine. Let's have the votes. Let's not block this bill and say, well, we wanted something better. That means you don't vote yes, you don't vote no, you vote maybe. Let's have some relevant votes, and let's vote on them. Don't let this get bogged down in procedural flim-flam that the American public hates. Have germane amendments, vote them up or down. And don't wait till next year on this. As both the ACLU and the NRA pointed out, every day that the Senate fails to vote on these reforms is a day in which law-abiding citizens have reason to fear that the constitutional protections so dear to the founders and so crucial to the functioning of our free society no longer apply. Echoing actually the words we just heard from the senator from Utah. Every day we fail to act is another day American businesses are harmed. One conservative think tank said that the mistrust engendered by the NSA's programs could cost the U.S. technology industry between $35 billion and $180 billion over the next 3 years. That's a staggering amount. So let's listen to the intelligence community. Ask the Director of National Intelligence. He'll tell you it's far better for our national security and for our fight against terrorism if we pass this. So I thank those senators for their support. Thank the Majority Leader for bringing this to the floor. I thank Senators Dean Heller and Mike Lee and Dick Durbin, Al Frank and Richard Blumenthal for their help. And I ask unanimous consent the statement of administration policy in support of this USA Freedom Act, as well as other items in support, be printed in the record. And I yield the floor.
Mr. President, I would yield 3 minutes to the senator from Florida, Senator Rubio.
Thank you, Mr. President. God forbid tomorrow morning we wake up to the news that a member of ISIL is in the United States, and federal agencies need to determine who this person is coordinating with to carry out a potential attack within the homeland. And one of the tools they will use is a tool that allows them to see the people they've been calling and interacting with, so we can disrupt that cell before they carry out a horrifying attack that could kill millions of people. Today, we are able to do that because of a program that collects those records and keeps them, not in the hands of anyone who's looking at them on a regular basis, but keeps them readily available to the government so the government can access those records and disrupt that plot. What this bill would do is take that apart. It would, in essence, ask the companies to keep those records in the hopes that they would. But under this plan, if this were to pass, if suddenly we were to go target these members of ISIL to find out who they are coordinating with, those records may not be there, and that plot may indeed go forward. And that would be a horrifying result. And here's why this doesn't make sense. First of all, we are rushing this to the floor of the Senate in the lame duck session on an issue that doesn't even expire until next year, on a bill that wasn't even listened to or heard in a committee, and they cannot cite a single example of this program ever being abused. Not one simple example of this specific program being abused by anybody intentionally. Not one. So we are dealing with a theoretical threat. The second thing is that even as we speak, law enforcement agencies investigating a common crime don't even need to go to a court to access these very same records. They could just issue an administrative subpoena and get a hold of them. So we are actually making it harder to go after a terrorist than it will be to go after a common criminal. And this is happening at a time when homegrown violent extremism is the single fastest growing threat to the United States. People here at home that have been radicalized even on the internet, and people that have traveled to the Middle East and been radicalized in the hopes of returning and carrying out attacks here. I would hope that this body would take more time to study an issue of this magnitude, because this program was specifically designed to address what the intelligence gaps that existed after the 9/11 attacks. Because I promise you, if God forbid any horrifying event like that were to happen, the first question we will be asked is, why didn't we know about it, and why didn't we prevent it? And if this program is gutted, we will not be able potentially to know about it, and we will not be able to prevent it.
The senator from Vermont.
Mr. President, of course, this program does not gut it. It actually enhances it. Secondly, if this was important to stop ISIL, ISIL never would have started. The fact is we had this program way beyond anything anybody's talking about today. It didn't slow up or eliminate one iota ISIL. That's a straw man that we shouldn't even have here. It has no effect on that. Everybody who's read the intelligence knows that. I yield 3 minutes to the senator from Connecticut.
The senator from Connecticut.
Thank you, Mr. President. I want to begin by thanking our very esteemed colleague, the chairman of the Judiciary Committee, Senator Leahy, for his leadership on this issue, and my colleagues whom he has named who have helped in drafting and crafting this very important piece of legislation, and to my friends and colleagues across the aisle, like the senator from Utah, who have supported and helped to make clear that this bill advances the cause of safeguarding our nation without in any way detracting from its essential operational intelligence capabilities. In fact, National Intelligence Director Clapper has said, and I'm quoting, "The bill will retain the essential operational capabilities of the existing bulk telephone metadata program while eliminating bulk collection," end of quote. This bill increases trust and confidence and credibility of our intelligence system. It advances that trust and confidence in the capability of government surveillance to do its job, but at the same time protect our vital privacy interests. It advances the cause of constitutional liberty and the appearance and perception of trust in that system. And it does so by making the Foreign Intelligence Surveillance Court look like and function like the courts that we are accustomed to seeing issue search warrants in the criminal process and protect essential liberties. It does it by strengthening, in fact, installing an adversarial process so that more than just the government's version of the facts and law are presented to the Foreign Intelligence Surveillance Court. It does it by providing for appellate review, just like we have in normal civilian courts. And it does it by increasing the transparency and accountability of the FISA court system. Our founders would have been astonished and appalled to learn that we permit warrants to be issued by a secret court operating in secret, issuing secret opinions, making secret law, much like the Star Chamber did. And that's why this reform is so profoundly and historically important, because we make the FISA court one that we can more aptly and abundantly trust, one that will have credibility and confidence. I support this bill. I thank my colleagues for showing that we can work together in a bipartisan way to safeguard the essential rights of Americans at the same time that we protect and preserve our national security. Thank you, Mr. President.
Mr. President.
The senator from California.
Thank you very much, Mr. President. I'd like to speak to this bill, and I'd like to say that this is one of the few times that my vice chairman, the distinguished senator from Georgia, and I have a disagreement. I very much support this 215 program. The Intelligence Committee, I think in a year, has had maybe 12 hearings on the subject. Many people think, well, we're using this program all the time. In fact, in year 2013, it was used 288 queries, and those queries went, 12 of them, went for a probable cause warrant. In fact, you cannot collect content in a query. It is just the metadata. Then the next problem has been, well, the government shouldn't hold the metadata. And this essentially is the big change that this bill makes. We voted out of our committee by a vote of 12-3, a FISA Reform Act. However, that bill is not going to pass, in my judgment. May I ask that my time be extended, please?
Is there objection? Without objection.
Thank you very much. I talked with the House, and here's what I got. If we didn't pass the House bill, there were members that wanted to end the whole program. I do not want to end the program. I'm prepared to make the compromise, which is that the metadata will be kept by the telecoms. Senator Chambliss and I wrote a letter to the 4 big telecoms, and we asked them if they would hold the data. The answer came back from 2, yes, and the answer came back from 2, no. Since that time, the situation has changed, not in writing, but by personal testament from 2 of the companies that they will hold the data for at least 2 years for business reasons. Now, here's the problem. The mandate that was inherent in the 215 Act is gone. But the fact is that the telecoms have agreed to hold the data. The President himself has assured me of this. If we do not pass this bill, we will lose this program. Senator Rubio sits on our committee. I listen to him with interest. I agree with him in what he has said about ISIL and others that will come after us if they can, and the only protection we have is essentially to disrupt a plot before it becomes a reality in this country. And the program is not widely used, as the 288 queries in a given year would indicate. Additionally, in this bill, and this should, I think, be of satisfaction to a number of people, the FISA court would have to approve a query before that query takes place rather than after the query. So I'm prepared to support the bill, and I do so for very practical reasons, because without it, I believe we will not have a program. So this is hard for me because I have a great committee, and I've tried to be supportive of those things that come out of our committee. I've talked to Senator Leahy. I've said the one big problem I have is the Foreign Intelligence Surveillance Court is upset with the language. He has said we will change the language. Senator Blumenthal has an amendment, which I assume will pass, which does change the language, and the major objection of the court, I believe, is ended by this language. If that's the case, and the telecoms agree to hold the data, and the data is not held by the government, but is held by the telecoms, I believe that solves what is a very practical problem. So, in any event, I've agreed to support it, and I thank the chair, and I yield the floor.
Senator from Georgia.
How much of the time on the other side has been used?
The senator from Vermont has 30 seconds remaining.
And how much time do I have remaining?
6.5 minutes.
Well, I've only had one speaker, and I had 15 minutes. Did he use 7.5 minutes, 8.5?
The chair was instructed that the senator from California spoke on the senator from Georgia's time.
Well, I would ask unanimous consent that the time that the senator from California used be added to my time, please.
Is there objection?
Mr. President, reserving the right to object, I will not object, but I was going to yield the remainder of my time to the senator from Texas, Senator Cruz, and I asked that he be allowed up to 4 minutes.
I would object to that. He can have your 30 seconds.
Then I will object to the request. I will not object to the request, and I will yield the remainder of my time to the senator from Texas, and I'm sorry the senator from Georgia would not offer me the courtesy.
The senator from Georgia without objection.
I would recognize the senator from Maine for 2 minutes.
Mr. President. Mr. President.
The senator from Maine.
Thank you, Mr. President. We need reform of the NSA programs, but not in this manner. Let's remember why this intelligence tool was put into place. It was enacted in the wake of the worst terrorist attack in our country that took the lives of nearly 3,000 people. And we have testimony from the former director of the FBI, from the former deputy director of the CIA, telling us that had this tool been in place, it is likely, most likely, that the plot that killed nearly 3,000 people would have been uncovered. Why would we weaken the ability of our intelligence community at a time when the threats against this country have never been greater? And let me address to my colleagues the privacy issue that has been raised, an issue that all of us care about. These data are far more safe, far more subject to privacy protections if they are held by the federal government, where only 22 vetted and trained government employees have access to them, instead of nearly 150 telecommunications companies that employ thousands of workers. And the government is going to have to go to those companies and ask for the data. That greatly exposes the privacy of individual Americans, far more than the current system. So for both of those reasons, I urge my colleagues to oppose the distinguished senator from Vermont's bill. It is a mistake, it would make us less safe, and we have expert testimony telling us that. Thank you, Mr. President.
Mr. President, I yield 2 minutes to the senator from Indiana, Senator Coates.
The senator from Indiana.
Mr. President, I regret I just have 2 minutes. It's unfortunate it's something that has this consequence for Americans is being debated in a limited time session here. We have 2 bills, one produced by the Intelligence Committee, written and supported by the chairman, a Democrat from California, and by the vice chairman, the Republican from Georgia. And it passed on a bipartisan measure with more than a 3-to-1 ratio. And here we are trying to go forward, allowing only one vote on one bill. Why do we have to rush this through in a lame duck session when it has such consequences? And when the director of the agency that oversees us, when asked in a public session by me, what are the ultimate consequences of this, his answer was a compromise of our ability to detect terrorist attacks, and the consequence will be Americans will die. And when that happens, and those of us who go every day into the Intelligence Committee to know what the threat is, and it's greater than it's ever been, understand that eventually something will happen here, and people will turn to us and say, did you have every possible tool in place to try to stop this from happening? And if you didn't, why didn't you? Let's not have another repeat of 9/11 where the commission then comes to us and says, get the tools that you need. This has been so mischaracterized in terms of what it does and doesn't do. Even as I talk to my colleagues, they don't have a full understanding of what it doesn't do. It has more oversight than any other program in the federal government. We have enhanced it through our committee with hours and hours and hours of discussion. And here we have something coming out of a Judiciary Committee that wasn't even taken up in the committee, just brought here to the floor. So I would urge my colleagues to think this through before we come to a conclusion that we're going to regret later. And I thank the chairman or vice chairman for giving me this time.
The senator from Georgia. Senator has 5.5 minutes left.
Okay. Well, Mr. President, in closing, let me just say that there are any number of reasons why the substance of this bill is totally flawed. We live in a dangerous world today. We all know and understand that. And while this bill, the provisions in this bill wouldn't have prohibited ISIL from being formed, it didn't prevent ISIL from being formed. But what it does do is the provisions in the underlying FISA bill gives our intelligence community all the tools they need to make sure that when ISIL recruits individuals to go to Syria to fight, if it's Americans they're trying to recruit, we can find out about that. And we have under surveillance today any number of individuals who we think have been committed to jihad who live in America. Secondly, there's another part of their recruiting that is even more dangerous than asking young men and women to come to Syria to fight for ISIL. They want people to go into the parliament in Canada and start killing people. They want people to walk the streets of New York and pull out a gun or a hatchet or whatever it may be and start killing people. If we eliminate this program, and that's basically what the Leahy Amendment does, then we're going to take a tool away from our intelligence committee community that's not going to allow them to be able to interrupt and disrupt those types of terrorist attacks. Now, with respect to our privacy, folks, and gosh, we need to be really protective of privacy issues in this country. We live under a Constitution that has survived for in excess of 200 years. It has lots of privacy protections in it, and all of us want to see that happen. But let me just tell you what's going to happen if this amendment comes to the floor and should happen to pass. Today, the metadata that is collected by the NSA can be accessed by 22 individuals. 22. That means there's an opportunity for leaks to occur or for individual privacy rights to be breached by 22 people. If this amendment ever became law, all of a sudden, all of the telecoms are going to be holding this metadata information as opposed to the NSA holding it. All of those telecoms have thousands of employees, lots of whom have access to this, will have access to this metadata. So instead of having the potential for 22 people to breach the privacy rights of American citizens, all of a sudden you're going to have thousands of opportunities for the privacy rights of Americans to be breached. And let me just close by saying that this program has been criticized an awful lot simply because of the leaks that Mr. Snowden made because of his theft of government property. But the fact is, there cannot be one single case pointed to by anybody who can show that as a result of collection of metadata under 215, any American has had their privacy rights breached. It simply has not happened. It will not happen if we keep this program in place. Do we need to modify it? You bet. And Senator Feinstein and I did a good job of that, considering 10 amendments within our committee, voting on all 10 of them. Some of them passed, some of them didn't. And the bill came out of our committee on a bipartisan vote. This amendment of Mr. Leahy has not even gone to the Judiciary Committee to give the members of the Judiciary Committee the opportunity to review it, to file amendments on it, to debate it in committee, and vote on it. That's not the way this institution has ever worked, and it's not the way it should work here in a lame duck session with time running out, and particularly on this controversial and sensitive and important a program as the 215 FISA Amendment program. And I yield back.
The senator from Texas.
Mr. President.
Mr. President, how much time is remaining on our side?
1 minute.
Thank you, Mr. President.
Mr. President, many months ago, the American people were astonished to learn that the federal government was collecting bulk metadata of personal cell phones from millions of law-abiding citizens. This legislation protects the constitutional rights of privacy under the Fourth Amendment while maintaining important tools to protect national security and law enforcement. This is bipartisan legislation that enjoys the support of the intelligence community and also the tech community. The bill is not perfect, but in my view, we should take it up and consider reasonable amendments on the floor to make it better, but it is imperative that we stand together united protecting the Bill of Rights.
Senator from Georgia has 1 minute remaining.
Let's ask for the yeas and nays.
The clerk will report the motion to invoke cloture.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the motion to proceed to calendar number 499 S-2685, a bill to reform the authorities of the federal government to require the production of certain business records, conduct electronic surveillance, use pen registers and trap and trace devices, and use other forms of information gathering for foreign intelligence, counterterrorism, and criminal purposes, and for other purposes, signed by 18 senators.
By unanimous consent, the mandatory quorum call has been waived. The question is it the sense of the Senate that debate on the motion to proceed to S-2685, a bill to reform the authorities of the federal government to require the production of certain business records, conduct electronic surveillance, use pen registers and trap and trace devices, and use other forms of information gathering for foreign intelligence, counterterrorism, and criminal purposes, and for other purposes, shall be brought to a close. The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Alexander.
No.
Are there any senators wishing to vote or wishing to change their vote? If not, on this vote, the yeas are 58, the nays are 42. 3/5 of the senators duly chosen and sworn not having voted in the affirmative, the motion is not agreed to.
Mr. President.
The senator from Vermont.
Mr. President, obviously I'm disappointed by tonight's vote. I'm not new to this fight. I mean, we've had 6 hearings on this issue.